Well, thank you, everyone, and I especially want to first thank all of you for being here for the last panel. This is not an easy task to be the very last panel, but we're very pleased that you are all here to participate with us in it, and I am hopeful you will be as intrigued as I have been by these issues. We will be continuing the theme of integrity, independence, impartiality of judges, but we'll be taking it from the comparative approach that we were talking about in the last session to the actual international level and international courts and tribunals. I'm going to introduce our panelists in just a moment, but I wanted to first say that Professor Payton has done really quite a good job of thanking everybody who has been involved in this program over the last couple days. But there is one person he has neglected to mention. And so I wanted to thank that person. And that person is Professor Payton. He has lived and breathed this program for I don't know how many months or how many emails that have gone back and forth. So would you please just join me in acknowledging his We're all very appreciative of your efforts. So to introduce my panelists, I was trying to think of a way that I might do this somewhat differently. First, I will introduce them collectively in the sense that I know all of them. I have worked with them. They are friends of mine. And the reason I know all of them is that I met them all at the same place, same time, in 2003 in Salzburg, Austria, so that carries some international connotation already, at the Brandeis Institute for International Judges. This is an institute that Leigh directs, and I'll talk about that more in a moment, that brings together judges from all different international tribunals. Usually we go to programs that are designated for one area of law. It'll be international criminal law or international human rights. But this program is really quite unique in conception and brings together judges from the international criminal courts, from the international human rights courts, from the International Court of Justice, the Tribunal for the Law of the Sea, in case you didn't know there was one, and from other courts as well, the Caribbean Court of Justice. I'm sure I'm forgetting some, but it's been fascinating to see the issues that cross over for this whole group of international judges. So that's my collective introduction. Now I thought to introduce each one of them, because I know so much about each of them, I thought, well, why don't I just tell you what I find the most interesting about each one? And so they may be surprised to hear this. I could tell you that Leigh Swigart has a Ph.D. in cultural anthropology with a specialty in linguistics. That's interesting. She has spent quite a bit of time in Africa. She ran the West African Research Center in Dakar, Senegal, and I believe lived there for 6 months. She is the director of international justice programs at Brandeis University. She is the co-author of this book called The International Judge, which she would not show you, but I wanted you to be aware of. And for our students here, it's in our library, so you can check it out. And her presentation will focus to a certain extent on some of the research they did for that book. But the thing that I find the most interesting about Leigh is that not only does she speak French and Spanish and English, she speaks Wolof. Now, you may not have heard of Wolof, but I would like to say Nangadef.
Magnifique.
Okay. That is one of the main languages in Senegal. And so that, too, she is a linguist herself, as well as having that expertise. So we're very, very pleased to have Leigh here to give us diversity in terms of disciplines, since she's a cultural anthropologist, as well as an international perspective. Our next panelist is Justice John Hedigan, whom you met yesterday when he gave the keynote address. John, of course, is on the High Court of Ireland and also was, prior to that, a judge for 8 years on the European Court of Human Rights. And among other things, while he was there, he chaired a committee that ultimately promulgated a resolution on judicial ethics in 2008. He's had a very distinguished legal career, and he has also, of course, worked with the Brandeis Institute. But what I find the most interesting about John, and it was a toss-up. I couldn't decide between two things. One is that he's an avid golfer, and the other is that he is an expert on U.S. history. And remember, he's from Ireland, but he's an expert on U.S. history. He knows more than I will ever know about the Kennedys, I have to tell you. So if you have any questions about the Kennedys, this is your expert. So welcome. We're very, very pleased to have you on this panel. And then we have Judge Fausto Pocar from the International Criminal Tribunal for the former Yugoslavia. And in his role in the appeals chamber for that court, Judge Pocar is also in the appeals chamber for the International Criminal Tribunal for Rwanda. So among other things, he has an office in The Hague. He has an office in Arusha, Tanzania. He is a professor of law at the University of Milan. He has an office in Milan. And he now has an office here at McGeorge. Among other things Judge Pocar has taught here, he taught an international criminal law course last year here, and we hope he will be back again teaching. So we've had quite a connection with him there. He has been involved with the Brandeis Institute as well. And one of the things, again, here too, there are just too many things to tell you about him, but I think one of the things that I found the most interesting about Judge Pocar is that he's one of those few people in international law who is an expert in both private and public international law. So if you look at his schedule or hear him talk about his schedule, it's quite likely on Monday he is in Madrid giving a talk about jurisdiction and contracts cases, and on Tuesday he is in some other location giving a talk about joint criminal enterprise. So he goes back and forth in these worlds of international criminal law, private international law, and in addition to all of that, he served for 16 years on the UN Human Rights Committee. So just a wealth of experience and expertise is represented here on this panel, and we of course are very, very pleased to have you back here at McGeorge and on our panel. Now the format that we're going to do is slightly different from what we've done in the other panels. We will have our obligatory PowerPoint. Leigh is going to do that for us, and we'll present an overview of her paper on the interface between nationality and impartiality. And then I have a series of questions that I will pose to Judge Hedigan and Judge Pocar that will build on that. So we'll go through those questions and their responses to them, and then we'll open it up for everyone else to ask any questions that you would like. Before we begin with that, there are 3 points that I would simply like to raise with you to set the stage for what we're looking at when we start looking at international judges and the ethics of international judges. The first point is that we have a larger number of international courts and tribunals today, and even for those that have been pre-existing, they have higher caseloads today. So in other words, they've taken on a much greater significance because of the proliferation of these types of courts, as well as the work that they are doing. So many of you, and of course many of you in this room probably have heard of all of these courts, but of course we have the ICTY and the ICTR, the UN ad hoc tribunals set up to deal with the conflicts in the former Yugoslavia and Rwanda. We have the regional human rights courts such as John served on. We have the WTO appellate body that handles cases. We have the International Court of Justice, of course, and many, many others. We also have, and I believe Leigh will touch on this as well, a number of hybrid courts that are composed of both national judges and international judges. And we see this especially with some of the international criminal court work, such as in Cambodia, Sierra Leone, and Lebanon now. There's a special tribunal for Lebanon that has both national and international judges. So there are many parallels between the ethical issues that arise on domestic and international levels, but we also have a whole new genre of judges that are dealing with these issues. The second point is that there are additional challenges that come with having an international venue. Of course, within any domestic system, there will be different types of diversity, cultural backgrounds, ethnic backgrounds, other sorts of differences. But realize that now on the international level, we are adding in national diversity. We are adding in linguistic diversity, more so than one would find in a national system. And we're adding in differences in legal backgrounds and the legal cultures that people come from, as well as societal cultures. So there is a different type of issue that is going to come up in terms of how we look at judging and what sorts of ethics govern the judges. And that's not all. My third point is that there are issues that are somewhat unique in the international sphere related to credibility and compliance. One of the notable aspects about the international courts is they don't have the institutional structure that we find in a national system. We have 3 branches of government in the United States, and we have a judicial branch, and we have all sorts of institutional backdrops to this and support for these institutions. That is largely lacking on the international level, and that has certain implications for judging as well, because what the judges do takes on enormous significance in how they conduct the trials, to the credibility and legitimacy of the courts, and ultimately with whether the judgments are complied with by the courts. So those are 3 points that I think are worth just thinking about as we set the stage. And that is all the talking that I will do for now, and I will turn it over to Leigh to talk about this issue of nationality and what impact it has on the international courts.
Good morning, everyone. It was a great pleasure to be invited here to be part of this panel, and I'd like to thank in particular Professor Payton and Dean Parker and my friends here on the panel, and in particular Linda Carter, who's taught me a lot about law and about life since I've known her. I want to talk today about the issue of nationality among judges who serve on international courts and tribunals, and the impact that this particular judicial attribute has on the work of judging itself. International courts and tribunals are like their domestic counterparts in that they need to have public confidence in their judges and in the decisions of judges in order to have confidence in the whole judicial enterprise overall. And they look for the same kinds of judicial qualities. And Richard brought up the Bangalore Principles of judicial conduct, which, as you can see, have many of the same attributes that we've been talking about since yesterday, independence, impartiality, integrity, and so on. These principles were developed by over 80 chief justices and high court judges from around the world over a number of months, and were adopted, I believe, in 2002, and are widely referred to throughout the world. International courts are also like domestic courts in that they recognize that there are particular relationships that judges have to parties before the court, to the cases that might give rise to questions of bias or the appearance of bias. But international courts have to deal with something, they have to contend with something that domestic courts are not, and that's the nationality of the judges who serve on them and what impact this might have on the cases that they are sitting on. And this is a concern in all the major categories of international courts and tribunals: human rights courts, interstate dispute courts, and also international criminal courts. But nationality isn't an identifier that just points to citizenship. By extension, it can also imply other characteristics that judges have that are pertinent to their work. And this would include linguistic knowledge and preferences, culturally embedded worldviews and behavior, some of which a judge may not be aware, and also the professional understandings, perspectives, and habits that come with a particular form of legal training. So I'm going to try to touch quickly on all of these issues and what I call the issues beyond nationality, and then we can turn to the judges themselves for commentary. Okay. Nationality management, that's how is the issue of nationality actually handled by international courts and tribunals? Some critics of the international justice system have contend that it's more of a these are political institutions more than legal institutions, and that international judges may be more political than judicial agents. And it's true that states, that is, governments, are very involved in the establishment and the writing of the statutes and all the documents that kind of go into the establishment of these courts. And obviously the most visible intersection between law and politics for an international judge is the question of nationality. It's something we don't have to think about in domestic courts. Everybody has the same nationality. And what's interesting is that while most international courts and tribunals address in some way the nationality of their judges for what may be seen as a potential bias that goes along with a particular national allegiance, they come up with some pretty different ways of dealing with it, and sometimes polar opposite ways of dealing with it. So let me just make a couple of points that are important to understand when we talk about a national judge. No international judge, like any judge, no international judge is an advocate for his or her country. It's a judge like any other judge is supposed to be impartial. However, some courts, and in particular courts who have the same number of judges as the number of states parties to a court, have the right to appoint a judge that sits in respect of that country. And this judge is often called the national judge and has a particular association with the country he or she comes from. So let's go to some examples. The African Court of Human and People's Rights is a new court, relatively new, established in 2004. The first bench was elected in 2006. It's a regional institution that was created by the African Union. There are 53 member states in the African Union, and they elect 11 judges across the entire continent. The African Court has adopted an approach to nationality that may immediately strike us as very reasonable, and that is that a judge who's a national of a state that is a party before the court cannot sit on that case. They remove themselves altogether. And indeed, it issued its first judgment in December 2009. The judge Michelo Yogogombai versus Republic of Senegal. Senegal happens to have a judge on that bench, and the judge did not sit on that case. The European Court of Human Rights, the institution of our friend Justice Hedigan, is sort of an older sister court to the African Court of Human and People's Rights. It approaches the issue of nationality in a very, very different way. The European Court of Human Rights, as Judge Hedigan mentioned, covers a huge geographic jurisdiction in the entire Council of Europe with 47 states. Among them, they have perhaps over 40 official languages, a huge diversity. And most of the cases are brought by individuals against states. Now, given this diversity, the court has decided that it is important for the judge whose state is before the court to actually sit on that case, because he or she will have a particular legal, linguistic, and cultural background to bring to that. And in fact, that judge usually is the judge rapporteur, meaning he or she organizes the documents and proceedings of that. Now, it's interesting to note that while the judges who sit in respect of a state are usually of the nationality of that state, it is not a requirement. And there have been cases where a state that may not have a person who has the qualifications or experience to sit on that will have a national of another European state, another member of the Council of Europe, to sit in respect of that state, which is the case with Liechtenstein, which has had 2 Swiss judges sitting in respect of it. And Liechtenstein also had the only non-European judge ever to serve on the European Court of Human Rights, and that was a Canadian. So if you look at that, if you actually have a non-national of that state, the rationale for having the national and local expertise that comes in sort of falls apart. But in fact, usually the judge is a national of the state in respect of which he or she sits. The International Court of Justice in The Hague, this is the oldest international court, established in 1948 in the wake of World War II. It resolves disputes between member states of the United Nations, 192 states. There are 15 judges on the bench. And what's interesting is that the International Court of Justice, obviously you have 192 potential parties to this court. You have 15 judges. And the parties that have judges sitting on the bench are thought perhaps to have an advantage. But instead of those judges recusing themselves from a case involving their state, in fact, the other state that doesn't have a judge on the bench is allowed to appoint an ad hoc judge to sit for the duration of that case, so that every state before the court always has a judge that they have appointed sitting on that case. And often there are 2 states, neither of which have a judge, and so they each have an ad hoc judge. Now, on the face of it, this seems very similar to the European Court of Human Rights strategy, which is that you need some insider knowledge to help with the resolution of a case, to bring that particular perspective. But in fact, at the International Court of Justice, most of the ad hoc judges are not of the nationality of the states that appoint them. In less than half of the incidents, the judges who have sat on cases, less than half of them have been of the nationality that is before the court. And instead, states usually appoint as an ad hoc judge a judge who has a knowledge of the ICJ itself, knows how the court works, knows, has some sort of a sophisticated kind of relationship with that institution itself. And a number of ad hoc judges have actually been former members of that bench. So once again, that sort of breaks down the idea that what you're looking for is this particular insider perspective. Now, the court on its website says an ad hoc judge is helpful because they will have a particular perspective from the party before the courts. And they also say that the ad hoc judge will sit in on terms of complete equality with his or her colleagues. Now, in a very informal sort of discussions with a current ad hoc judge, he's in fact reported that he's not taken very seriously by the regular members of the bench because they assume that he's biased in favor of the state that has appointed him. And he said that other ad hoc judges have felt the same way, that because a regular member of the bench would have recused him or herself, well, himself, there's very few women on that bench, if there had been some sort of appearance or the reality of a bias. So just to note, the European Court of Human Rights also has the practice of having ad hoc judges if the so-called national judge is unavailable or the post happens to be unoccupied. And a judge of that court mentioned that if there were a case where the ad hoc judge in the chamber, 7 judges were the deciding vote, it would create an enormous amount of tension. International criminal courts. As I said, the issue of nationality is perhaps most salient in courts where states themselves are the parties. But it can also arise in the context of international criminal courts where individuals are on trial. And the issue of whether judges who are from the actual regions where the crimes in question under investigation took place, are they going to have the the required impartiality, sit on those cases. Now, we look at the so-called ad hoc tribunals of the United Nations, the International Criminal Tribunal for the former Yugoslavia in The Hague, and the International Criminal Tribunal for Rwanda in Arusha. And in fact, since 1994-95, when they were established, there's never been a judge of either from the Balkan region or from Rwanda sitting on those benches. And in speaking informally with judges, they simply say they wouldn't have the distance on those crimes. If they were on the bench, they might actually have to recuse themselves very frequently, which would be an impediment to the smooth functioning of the court. That makes sense. And the sphere of bias for people who've actually been present in zones of conflict seems quite reasonable. But then we get to the hybrid criminal courts that Linda mentioned before. And in fact, in their statutes, they call for a mix of local and international judges. So they have the opposite take on this, that you need to have the local and international judges, and also they apply both international and domestic law, or domestic law, the international law that's been enshrined in domestic law. So the whole idea is that you will have this mixture. Now, do these judges, are they able to judge with impartiality? That's a question some people have. Some people say no, some people contend that yes, they can be impartial. Another interesting point from an international judge sitting on one of these courts to me was that she thinks that the national judges don't get proper protection because, in fact, they're taking great risks in sitting on the benches of courts that are looking at these kinds of crimes. So, in general, then, it's clear that courts are thinking about the question of nationality. They want to ensure that there's proper independence and impartiality on their benches, and that they really have found these different strategies for managing nationality. And I hasten to say that any studies that have been done on courts that have national judges, the ICJ, ECHR, it has not been borne out that judges always vote with their states. In fact, it may be true that judges tend to vote more often with their states than or against their states, but even ad hoc judges occasionally vote against a state that has appointed them. So what's really, and if a judge does vote with his state, it might have nothing to do with national allegiance whatsoever or bias. It may have to do with other very solid legal grounds. So these things are hard to pull apart. But as one scholar has said, this sort of focus on nationality and the nationality of judges really is a product of what he calls the prime mode of identification of actors in multinational context. Nationality is very, very out there. This is what we're thinking of. These are international institutions. But the same scholar also fears that international courts will be diminished if they remain mired in increasingly dubious questions of nationality, citizenship, and consequent doubts about judicial independence. So even if it's just an appearance of bias, there's a problem with this focus on what are the implications of nationality on international benches. So let's go beyond nationality. Nationality is an obvious thing to focus on. It's visible. We all understand what the content of nationality is, more or less. But what other kind of labels could be used to characterize judges who sit on international courts and tribunals? And what are the other attributes or qualities that might be relevant when we talk about impartiality and independence and a general balance in courts and tribunals that cover wide jurisdictions? Are there certain kinds of attributes that could also have potential impact on the way that they do their decision making? And what do these other attributes have? Well, how do they impact the general work of international courts and tribunals? Well, first, let's talk about legal tradition, which Linda brought up. The statute of the International Court of Justice says the electors shall bear in mind not only that persons to be elected should individually possess the qualifications required, but also that in the body as a whole, the representation of the main forms of civilization and of the principal legal systems of the world should be assured. Well, what does that mean? It basically comes down to that we have judges of two different legal backgrounds, common law and civil or Romano-Germanic law. Now, of course, some judges may have expertise in other kinds of law as well. They may have expertise in Islamic law or another body of religious law, in a local customary law, and so on. But generally, they come from these two legal backgrounds, and so all international courts and tribunals find themselves with mixed benches. Of course, these two legal traditions are quite similar. They're both Western-based, and they do have some important differences, but this plays out mostly in the context of international courts, of international criminal tribunals, where the different adversarial and inquisitorial styles of conducting a trial mean that some judges may be unfamiliar with particular kinds of procedures. So the question is, what impact does this have overall on international courts and tribunals and the work of international judges? And I think the answer is people think it doesn't have that much of an impact beyond these international criminal tribunals where they deal with it. And I just offer this quotation from Thomas Bergenthal, who is the judge of U.S. nationality sitting right now on the International Court of Justice, who says, yeah, we're from legal traditions, but we're working in international law, and international law is a different system. And beyond that, a lot of us have studied in the same places. We have a similar mindset, similar training, and so it's not, it's a unifying factor. It's not that big a deal. But some have argued that international law as a body of law is rather amorphous, based on custom. It's not as clear-cut as other bodies of law, and that one of the consequences of this is that international judges, when in doubt, look to their judicial roots for guidance. That is, they look homeward, which I'm trying to convey by this idea of national flags, but when I look at that, it's not the most clear-cut visual aid I've ever seen. And so does this tendency to look homeward then introduce another kind of bias, which is not through national allegiance, but in fact through reference to one's own legal system and style of legal reasoning? Some people think that common law is becoming kind of the driving motor in some of these, in the development of international law in some of these tribunals, not because all the judges have a common law background, but there's a lot of other people, legal staff, legal officers, people who've had training in common law. Even if they come from a civil law system, they may have done an LLM in a common law country, and so that there's more frequent citation of common law than of civil law sources. And some people think that this is, there's a disproportionate sort of referencing of common law. Now, what about language? I'm very interested in how language plays out in these very multicultural, multilingual institutions. Let me just start by saying that you have judges who come from many, many different countries, but international courts and tribunals established usually two working languages. English is almost always one of them across all of these courts. French is often the second one, which is sort of a UN tradition. French used to be a very, very important world language. In other cases, in the Inter-American Court of Human Rights, it's English and Spanish. So it depends on what the dominant language is in the particular region of the institution. However, what's kind of interesting is that English is a dominant language in international courts and tribunals, much like it's dominant in so many other spheres of activity. And this can be an issue in the sense that if you have two working languages and most of the judges, in fact, don't speak one of those languages, there ends up being a preference for English. And when you look at the judges who come, for example, from Latin America or from Asia, if they speak one of the working languages of the court. If it's not their native language, they tend to study English instead of French. So French is sort of becoming less important, much to the distress of the Francophones, and English is taking on of greater importance. And some people think that that is in itself an impoverishment of the international, the setting, the context of international courts and tribunals, and that in fact judges should strive to be multilingual, or that perhaps in the selection and nomination of candidates, they should look for multilingualism. So I wanted to bring that up. Now, that's sort of a problem that comes with the restriction of language. Most of the problems in international courts and tribunals have to do with the multiplicity of languages. The judges obviously have to speak to one another. They have to, sometimes they work on mixed panels where they don't share a common language. That can be an issue for discussion and deliberations. There's a huge dependence, very heavy dependence on the translation of documents and interpretation of oral proceedings, which can cause problems, especially when you're talking about languages that don't have a written tradition. You need to have trained interpreters, simultaneous interpreters. I mean, there's a lot of issues that come up with that. There's not exact semantic equivalence in legal terms or other terms between languages, and in certain delicate situations that can create a problem. And then, of course, there's the cost issue. The cost issue is enormous. But I want to offer this comment by a judge of the European Court of Justice, which is the EU court in Luxembourg, who says, well, what do we do? I mean, we have to embrace multilingualism. We have to assume that cost, because that's a cost that's inherent to a democratic order. So, culture. So this is a very, very amorphous, huge category to examine, and I was very pleased at the last session that some of these issues came up of culture in judicial training. Even if judges have been trained in the same legal tradition, they may have very different views on lots of parts of their work. After all, a common law judge can come from the UK or Kenya, and a civil law judge could come from France or Cambodia. And those are judges who are going to have very different life experiences, very different perspectives, and they've been shaped by where they have been brought up. So what are some of the arenas in which cultural difference might have an impact on judicial work? Judges may have different ideas of a work ethic. This could be reflected by how many hours a day they put into their judicial work, how much they delegate to their legal assistants, what kind of effort they put in when there's a collective work of a panel. Judges may come from societies where formality and hierarchy are respected to different degrees. They may have culture-specific expectations of gender behavior that plays out in particular ways. They may be more or less civil in address in the context of the courtroom or other professional contexts. And more fundamentally, there may actually be very different notions about what justice is and what are appropriate punishments, and those may be beliefs that they hold very deeply that are not very open to conscious analysis. So, however, having said that, by virtue of having gotten to the position of being a judge on an international court and tribunal, a lot of these people are very cosmopolitan. They have adjusted their behavior and their perceptions to sort of an international kind of personality. So this may not be as big a problem as you might at first think. What else counts beyond nationality, language, culture, legal tradition? When we look at the organizing principles for humanity, nationality is big, but there are other ones that we think about all the time. Race, religion. These are issues that are in the news all the time that bring up all kinds of human issues and conflict. And yet they're really invisible in the context of international courts and tribunals. There's no provision made for racial balance, for religious balance. And yet, in some ways, nationality can be kind of a cover for these things. One would assume that judges from sub-Saharan Africa will be black, judges from the Far East will be Asian, a judge from Pakistan is presumed to be Muslim, a judge from Ireland is presumed to be Catholic. But these issues are not talked about, and I think it's an interesting question, because could they not also, these attributes, be a source of bias? Or alternatively, could they not be a source of insight? But silent on that. I want you to look at the picture of this, this bench. This is the bench of the International Tribunal for the Law of the Sea. It's been in operation over 20 years, 21 judges. You can look, they look like they're from all over the world, but there's one category of humanity that's missing there, and that is women. So gender is the one other category of humanity that is being addressed in some courts. The European Court of Human Rights, the African Court of Human and People's Rights, and the International Criminal Court all make provision in their statute or in their rules of the court for trying to strive for some sort of gender balance. And overall, women are very underrepresented across the spectrum of international courts and tribunals, but in the courts I just mentioned, there is much more of a balance. What's interesting is that human rights and criminal courts are the ones that are very conscious of this, and I think one of the reasons is that people believe that women may have a particular insight into women's rights or the kind of crimes that come before the benches of international criminal courts, for example, crimes of sexual violence that disproportionately affect women. But I mentioned that the International Court of Justice, in its 60-plus years of operation, has only had one woman ever, Rosalind Higgins of the UK, who served with great distinction and was the president during her final years on the court. So what about these issues that are behind nationality? I mean, are they really important? Do we need to think about them? Should they be considered just as much as nationality? Should none of them be considered when international judges are being nominated and elected or appointed? And I just want to, for food for thought, I want to bring up some current challenges that are going on in the extraordinary courts, chambers in the courts of Cambodia. This is a tribunal, a couple years old, that was created to look into the Khmer Rouge atrocities in the 1970s. So this is sort of an unusual model in that it's 30 years after the fact. And it was a long time in trying to figure out the structure of this. Now, the ECCC just completed its first trial. And the person on trial goes by the name of Duik. He was the former prison chief with Cambodia's Khmer Rouge, and he oversaw the torture and killing of more than 15,000 men, women, and children. And he is facing charges that include crimes against humanity, war crimes, torture, and murder. Now, let me just read you something from something that came out a couple weeks ago from the Open Society Initiative, Justice Initiative, that is describing what happened in the closing of his trial. The closing arguments of his trial were dramatic. Counsel for Duik reversed the position consistently articulated by the defense throughout the 6-month public trial, in which Duik acknowledged responsibility for the charged crimes and asked for mercy from the court and forgiveness from the victims. During the closing arguments, Kar Savuth, Cambodian counsel for Duik, and Duik himself surprised the full courtroom, as well as Duik's international co-counsel, Francois Roux, by requesting an acquittal and immediate release. The sudden turnabout revealed significant differences between Duik's international and Cambodian defense counsel. In the final moments of the argument, Duik confirmed that Cambodian defense counsel Kar Savuth spoke for him in requesting acquittal and immediate release. And look at this. This is an interview from the spokesperson, and I just want to point out what he says, that the case was complicated in terms of the laws involved, the differences in languages among international Cambodia judges, and their search for a suitable punishment. And I just bring this up because I think this is sort of an illustration of the kind of issues beyond nationality that I've brought up. And they're playing out very powerfully in the extraordinary chambers in the courts of Cambodia today. So what does this all mean? How do international judges make this work? How do they do their work on the bench with all this diversity? And just very quickly, through the study that I did with 2 colleagues and the book we published on international judges, sort of despite all the odds, these benches tend to work. The diversity poses a lot of major challenges, but I think that in the end, it enriches the benches, it brings different perspectives, people can draw on the experience and the views of their colleagues, and that it's something, a kind of diversity that's necessary for the kind of cases that a lot of these courts are dealing with on a daily basis. One international court president said that when he was interviewed, said that he looked at his bench and he said, how can this possibly work? Judges from all over the place, different backgrounds, different professional experience, different languages. How can this work? And he said that he found that with time, the institution was so compelling that the judges were able to start working together and reconcile their differences in order to form a united approach to justice. And I think this united approach to justice is very, very important for these international courts and tribunals, which are vulnerable, which are still in a formative stage. People don't really understand them. There are questions continually asked about them. Are they necessary? Are they accomplishing their respective aims? Are they too political? Are they worth the expense? These institutions can't take for granted the support, financial and moral, that domestic judiciaries have automatically. And so it's important for people to understand and to have faith in these institutions, and questions that come up about impartiality and independence through the nationality of judges or other attributes, they can ill afford those. They could do harm to those. So what about at home? How does this discussion translate into the domestic sphere? Just as national judges may be suspected of partiality, U.S. judges from minority groups may be questioned about their allegiance to particular sectors of the U.S. population, with the suggestion being that this would sway their decision-making. And I think we all saw that with Sonia Sotomayor and her wise Latina comment. We all wondered if this was going to do her in. And I just want to point out the namesake of my university, Brandeis University, was considered irredeemably prejudiced during his confirmation hearings. And of course, he went on to become a very, very distinguished Supreme Court justice. So let me just end with the perspective of a veteran judge, an international judge who used to be a national judge. And I thought his comment was sort of interesting. It may still be wiser from a pragmatic viewpoint that international criminal judges not sit in judgment in cases involving their own nationals. It is not that international judges are any more likely to be biased in favor or against their own nationals than, for instance, a U.S. judge trying a U.S. citizen in New York. But it would be a potential perception of bias that can easily be avoided. In the UK, there are already black defendants wanting black jurors. So far as I know, that hasn't yet extended to a demand from, say, a Hindu to have a Hindu judge. I hope we can avoid going down that road at all and have a rule of law for what it is and ought to be. Thank you.
Thank you very much, Leigh, for that great overview. Really sets the stage for us and hopefully raised a number of issues that you may not have been aware of or thought about before. So let me launch right into questions, and we'll start hearing from Justice Hedigan and Judge Pocar. My questions are in three categories. The first will deal with bias-type issues. The second will deal with broader ethical issues. And the third will deal with the more amorphous category of other differences on judging and potential issues that arise. So my first question for you is, Leigh was speaking about the polar opposite approaches that have been taken by international courts. Some requiring, in essence, or permitting a national judge to be involved in the process, such as the International Court of Justice, the European Court of Human Rights, hybrid courts, and the others taking the position either explicitly or implicitly that a national judge of one of the parties should not sit. And the African Court of Human and People's Rights is an example. And de facto, the ICTY and ICTR have taken that position. So my question for you is, taking into account, of course, the difference in the nature of the courts, some involving states, some involving individuals, do you think that this nationality connection to a case brings insight, bias, or both? So, Justice Hedigan, what do you think?
Thanks very much for the interesting question, Linda, and thank you very much, Leigh, also for that extremely interesting and very well researched paper on the issues that you've raised here today, which I find very, very interesting. I suppose I'm reminded, I suppose, first of all, by some of the things that were said yesterday. You may recollect Judge John Irwin referred to what he called the illusion of objectivity. My fellow countryman Richard Devlin, fellow countryman and Canadian, Richard Devlin referred to the false god of impartiality. And I suppose that the problem is it's always a balance of things. There are great advantages to having the national judge involved in certain courts, but there are also disadvantages to having them. So when you look at the role of the individual court in question, whether it's the Court of Human Rights or whether it's the various tribunals or the ICJ, they would, because they have a different role to play, they may decide that it's not necessary to have, or not even desirable to have, a national judge. It depends on what the job actually is. And it depends on the judgment that's made. And that judgment is made on the basis of what is fair, what's reasonable, what's workable. I think in one of their confirmation hearings before the US Senate a number of years ago, it might have been even John Roberts in his hearings, referring to reasonable doubt, said, where does it tell you in the Constitution what is reasonable doubt? It doesn't, of course. It's a judicial function. Well, where does it tell you anywhere in international law what is a fair balance? There's nowhere it tells you. That's what judges are for. That's what people are for. And of course, it's not judges who actually make the decision as to whether there should be a national judge involved or not. That's essentially the people who have devised the structure in the first place, who are invariably the officials, legal officials and diplomatic officials of the countries in question. In the case of the Court of Human Rights, the decision was made by the founding fathers, and there were only fathers at that stage, that the national judge's presence was highly beneficial. That, of course, in ways reflected the fact that, as I mentioned yesterday, the initial concept of the Court of Human Rights was that governments would be suing governments, that governments would be keeping an eye on each other to see that they maintained proper standards of human rights protection. Ultimately, that's not the way the court developed. It developed as a court of individual petition where people, individual simple folk, could come. But how does it actually work in practice? Well, I must say, with almost no exceptions, I found no striking example of any kind of national bias having any role at all. I often said that, in fact, one of the main jobs of the judge in relation to impartiality, the striving for impartiality, I tend to agree with those two speakers I referred to, Judge Irwin and Professor Devlin, that it's a striving for it is what we are involved in all the time. Whether we ever achieve perfect impartiality is something I greatly doubt, because we are all the products of our background, whatever that background is. But in my experience on the court in Strasbourg, I must say I never came across a striking example of, I hardly ever came across a striking example of where nationality played a role. I do recollect one single instance of, a sad instance of a judge who was basically seen quite clearly when his country was in the dock to be playing defender. The result was a sad result, that he had absolutely no credibility of any kind whatever. No one paid the slightest attention to what he said. How could they? I mean, that's just not the way things work. Particularly when you bear in mind that certainly my experience of the Court of Human Rights and the many judges that I worked with on that court was that they were all, almost without exception, first of all, very able people, and secondly, very committed and very devoted to the concept of international justice and tried to do the best they could. So I think it's a question of horses for courses, to answer your question really. it's a matter of decision for the framers of these various institutions to determine whether or not the national judge should participate or should not. There's one thing I would like to point out in that regard, and that is that judges are not picked to act in respect of their country. They are elected. Élu au titre is the French phrase. They are elected in respect of their country. That's a phrase very carefully picked and always used to describe the judges, because it meant all the time, I am not the Irish judge. I'm not the judge from Ireland, and I'm not supposed to be. I'm the judge elected in respect of Ireland while I was there. And that's very important, because I owe as much of a duty to the citizens of Albania, Russia and the UK as I do to the citizens of my own country, or in fact the persons within the jurisdiction, because if an American is within the jurisdiction of one of the countries of the Council of Europe, they are protected by the Council of Europe, by the Convention on Human Rights, for as long as they're within the control. Secondly, just to finish off on that, or lastly, just to finish off on that, I can't help just noting that I, on the court, once discovered a somewhat amazing fact that's just relating to something Leigh said, where she said you would expect that judges from certain places would have certain religious backgrounds. It would be expected that the Irish judge would be a Catholic, and I was, of course, brought up a Catholic like 99.9% of the Irish. But when I went to Strasbourg, I discovered the judge from England was a Catholic, educated by the Jesuits like myself. The judge from the Netherlands, one of the most Protestant countries in the world, was a Catholic. The judge from Norway, which is Lutheran almost entirely, was a Catholic. And I asked, is there some conspiracy going on here? Have the Vatican been at work in a way that I'm not aware of? I don't think they had been. But it was an extraordinary fact that nonetheless there seemed to be this strange change. Now, it's fair to say that a number of those were women, and each of them were very much estranged from the Catholic Church on the basis of its attitude both to women and to certain other aspects related to the present problems that they have. So, of course, what you see on the surface is not always what you get underneath. It's ducks paddling on the water, as somebody said yesterday.
Thank you. I have one follow-up question for you before we turn to Judge Pocar. But first, with regard to the Founding Fathers, I would like to just point out, and Leigh had this in her slide, that every time we see somebody holding the scales of justice, is that a man or a woman?
It's a woman.
Yes, it is.
Minerva.
And so I thought I would just
justice.
point that out. Well, I wouldn't say that. I would say
no, she was the goddess. And in fact, the ancient Egyptians, Mat, the goddess of justice in ancient Egypt, is a woman. As well, you see her holding her beautiful wings out. It's based on the Egyptian idea of the bird who protects its young by spreading its wings out. And the goddess Mat spreads her beautiful wings to protect us all. The goddess of justice and the equilibrium of the world. It always seems to be a woman. But of course, they shouldn't be on the courts, naturally. You wouldn't want to get that confused. I jest, of course.
That won't be my follow-up question. My follow-up question is actually, your experience sounds like it's been very positive, or was very positive on the European Court of Human Rights vis-a-vis nationality. And there was some kind of an internal mechanism that if a judge appeared to be biased, the other judges gave that person less credibility. My question is, now that you're off the court, looking back at it, thinking about it, would you design the court that way, to have that nationality rolled into the chamber, or would you take the position of the African Court of Human and People's Rights?
I would include the national judge. I think it would be, I'd give it a lot of thought. I have given it a lot of thought since, in fact, the first time I was involved in any real debate about it, which was in Salzburg at the time we met. And I strenuously defended the role of the national judge on the court in Strasbourg, and Professor, his name just escapes me for a moment, the retired professor of law at that university strenuously opposed that, and I was quite pleased to be supported by your Justice Anthony Kennedy, who felt that it was important that there should be a national judge for reasons of confidence in the judgment itself, and that is very true. If you have to accept the judgment of a court, an international court, it might make it a little bit difficult for you if the entire court consisted of foreigners, if you like. even though you have accepted an international jurisdiction. So it's quite significant. But there is one other most significant practical factor that is actually involved in this, and that is that it's very important that, that there should be some judicial oversight of the entire preparation of the case, because the way a case is prepared can, to a great extent, impact upon the result at the end, particularly in a system where, unlike the common law, the hearing is not actually the central focal point of the whole decision-making process. It's a written submission system and so on. In many cases, the national judge will be the only person who can read the language in the file, the letter that's written originally to complain, perhaps the newspaper articles, the account of the proceedings in the national court. If you are the Croatian judge, you are the only person on the court who speaks Croatian. No one else does. And you have to remember that with the exception, there are two languages in the court, English and French, with the exception of the Irish and the English and the Maltese and the Cypriots to a certain extent, they're the only native English speakers, and the French, the Andorrans, the Belgians, they're the only French speakers, and the Monegasque. So everyone else is speaking a foreign language, and when you add in on top of that then the domestic language of the country in question, that's too much to ask. So there's great oversight by the national judge in being able to read the file and to be able to assure all the other judges, even if by means of not saying anything, not raising a problem, that in fact the registry have translated everything absolutely perfectly, they've got everything right, and the description of what has happened in the particular country does hang together as a logical account of how things work in that particular country.
Thank you. And Judge Pocar, you of course are serving on a very different kind of court, on the international criminal courts for the former Yugoslavia and Rwanda. What are your thoughts about the nationality issue?
Well, first let me thank for participation to this invitation to participate in a stimulating workshop. Let me start from the last point made by my colleague. I tend to disagree with him on the participation of the national judge. And it's true, if we say this judge gives the perspective, has the perspective of what happens in the country, can read, but isn't there a problem of possible bias which will not be apparent? Because if the decision of the case depends to a large extent on the preparation of the case, and that judge is the judge who in fact is the one that can better prepare the case, he may prepare it in a certain way, and this will not appear in any moment. So without defending necessarily his country, he may prepare the case in a way that will lead to a certain solution for his country. So at the end, I believe it would be preferable not to have the national judge in a bench. I go back to my experience in the Human Rights Committee, which has a similar approach in dealing with cases. There we used the national member of the committee did not participate in the decisions, could attend the meeting, could be present, be asked questions by a colleague, clarify issues if colleagues wished to have these issues clarified, but then did not participate in the decision at all, and had no say unless questioned, unless asked to give his clarification about the law, for instance, of the country. If I look back at that experience, in many cases, the participant members of that country tended to protect the country. So on the whole, I think it would be better not to have that. Also as a perception outside. But there is an advantage. I recognize the advantage of having the national judge in the acceptance in that country of the decision. because the country will, the people in the country will see themselves protected by the presence of the judge. So at the end, it's always a protective function, which is, I would say, definitely the case in the ICJ. The judge, the national judge, is protecting the country. It's true. Leigh is correct when she says the judges ad hoc frequently didn't vote for the country. But what about the permanent judges? If one looks at the permanent judges, the statistics are clearly in the sense that the permanent judges vote for his country. I say his because in most cases they were just men and not women. But the practice is a protective practice. And I see the point that it's important to have the national judge for purposes, for instance, of accepting the jurisdiction. I mean, in Strasbourg at the beginning, it was not compulsory to accept the jurisdiction for individual cases. And of course, states may have been pushed to accept the jurisdiction also because they had a judge in the panel. It certainly is the case for the ICJ. Accepting jurisdiction without having a judge of the country will not be seen as acceptable. We should not forget that international jurisdiction is a deep interference in internal affairs of a country. Accepting this binding a decision that comes from outside is not obvious. It's not obvious for any country. We know the difficulties, for instance, in this country to accept a decision of the ICJ as binding. So it is an interference in the sovereignty of the domestic jurisdiction of the country. So at the end, well, I wouldn't say more on this at the moment. It's difficult to make a general assessment for all the courts. The courts have different functions. And if I come to criminal courts do not have the national judge, except for the hybrid courts, of course. But truly international courts do not have the national judge. Is that a good thing or a bad thing? In my view, it's more bad than good in this case. Probably because the model of the hybrid courts is the best one. But not again from the point of view of the decision, from the point of view of the perception. The real problem of the international criminal courts is the perception of bias in the population affected by the decision of the court. The acceptance, for instance, of the jurisprudence of the ICTY in Serbia is very limited. Is very limited. The statistics, the polls show that perhaps 20% of the population, it's already high levels, accept really, do not consider the jurisdiction of the ICTY biased against the Serbs. If there were Serbian judges, it would be different. It would be certainly different. But sometimes it depends also the composition of the benches. We should not forget that the ICTY composition has a huge number of judges which come from NATO countries. And it's obvious that the perception by the Serbians of decision coming from judges, national NATO countries, cannot be a positive one. Maybe it's just a perception, but bias, yesterday we were discussing perception of bias and actual bias, but at the end, I believe it's more perception than actual. I mean, judges are very rarely biased, but the perception may be very frequent of bias, and we should take care also of the perception of bias. So perhaps the model of the criminal courts, of international criminal courts, still has to be refined, and the hybrid solutions are probably the better ones. There is another advantage in having judges of the country in criminal courts, and that is that these courts are dealing essentially with post-conflict situations in which crimes were committed and heinous crimes were committed during the conflict, and these states have to be rebuilt in a way. There is a question of, especially judiciary, has to be rebuilt. And if you put together judges appointed internationally with local judges, there is a sort of educational process which is extremely important to build capacity. And we were discussing, it was very interesting before, the teaching judges, training judges, but judges do not like to be trained. Because they are judges, and they don't accept being trained. The only thing they accept, this is our experience in the ICTY, is acting in a sort of partnership with other judges, between equals. That's sharing experiences, but in fact you train them, but it should be put in a way that will not offend a judge who considers himself as already trained and already having the capacity to deal with the matters.
Thank you. And in fact, I was just thinking as you were saying that maybe it's a linguistic issue about the use of the word training. And we'll see if Leigh can comment on that in a few moments. But I wanted to go back to a couple things and follow up here. One, we've already, to a certain extent, woven in the question that I would have posed about the perception of bias and how important that as an ethical standard is in the international courts. And so I'll leave that for a moment. But I wanted to go back to the illusion of objectivity, the unconscious biases that Judge Irvin started us off with, and Professor Devlin talked about and John referred to. And my question here, and Judge Pocar, I'll go to you first on this one, is whether you think there is a greater or lesser danger of unconscious biases in international courts compared with national courts?
Well, that's a question difficult to answer. In principle, I do not believe there is a great difference between the position of the international judge and a domestic judge as to unconscious prejudices. There is one issue, however, I think of that may be a general issue, a more general issue on ethics, which goes also to unconscious bias to a certain extent, and it's the difficulty for international judges to resolve the problem of their accountability, which is an issue that domestic judges have less, because accountability for a domestic judge is a notion which is more or less clear, to the extent that the notion of accountability can be clear, which is not obvious, especially in the international world. I mean, I heard a president of the ICJ, International Court of Justice, a French president in the past, Judge Guillaume, publicly in the workshop saying that accountability does not exist. It's a notion which has no meaning, and simply because it cannot be translated into French. And his assumption was that if a notion cannot be translated into French, clearly does not exist. That was his position. But he didn't say it as a joke, but we can look at it as a joke. But the point is that the problem of accountability exists also for international judges, but to whom are they accountable? For domestic courts, that's relatively easy to decide. They may be accountable to the community in which they work, but which is the community for an international court? Is the international community? And what is the international community? Is a community of states? Are they accountable to states? That's the normal notion in international law, because they represent, they're appointed by states, they represent states, and the international lives are made by states. But it's that true that international judges should be accountable to states? Perhaps that's to the community of states. That's perhaps the case for the ICJ, for the Tribunal of the Law of the Sea. But is that the case for human rights courts? Is that the case for criminal courts? Or are they accountable to a larger international community, which is the community of states and of people, of individuals? And for courts that have a geographic jurisdiction, isn't that primarily the community where they exercise the jurisdiction? For instance, the Balkans for the Rwanda, or the region related to Rwanda in other cases, and which is the ethical problems that this raises. So, should we consider, I'm putting more questions than answers, of course, because is the accountability of judges associated with their election? Then it would be necessarily the community of states. But when they deal with individuals, there is a recent study of a German lawyer, Professor Bogdandi of Heidelberg, the director of the Max Planck Institute in Heidelberg, who is titled, "In Whose Name?" International judges decide in the name of whom? They're accountable to whom at the end? It's not really clear, because the international community is still a problem. I believe judges should be accountable to the individuals, to the community of individuals, like domestic judges. That's why I come back to the question, there should be no difference in the position. But it's true that in some cases, especially for the courts that decide interstate disputes, it might be slightly different. But this is a problem that goes hand in hand with ethics, because the decision may be one if you look at a state community, and different if you look at the individual. Also, I go back to something that Professor Devin said yesterday on the substantial law and the formal law. Sometimes it might be enough for the states to have a formal decision according to international law, and if you go to an individual, you have to look at the substance and make a just decision for the individuals, not for the states necessarily.
Related to the issue of accountability, and I know Leigh wants to jump in here too, maybe I'll just jump to one last question, because I do want to allow time for people to ask questions. But related to accountability, we're talking about accountability to whom, but I think there's also the question of for what. In other words, what kind of, we've talked a lot about different codes and standards and mechanisms of enforcement. What exists on the international level? So to whom and for what and how are the questions. So Leigh, did you want to make a comment first?
I just wanted to briefly make a comment about, in particular, international criminal tribunals. It seems to me that there's often a lot of dissatisfaction on the part of the victim community about the work of these, and in their sort of mission statements, these courts, for whatever reason, perhaps from NGO pressure, have said that, you know, their work will contribute toward reconciliation in the affected regions. And I mean, I think a big question is, are courts really institutions that can do the work of reconciliation? they're trying individuals. These individuals will be, you know, held accountable for their crimes. They'll be found guilty or not. But is their conviction or acquittal going to do really the work of reconciliation? And I know that in Sierra Leone, there's a lot of frustration because of the amount of money going into the special court for Sierra Leone, and victims are saying, you know, we need a lot of basic things in our society, and who made the decision that all this money should go toward there? So I'm just saying that I think that the whole idea of accountability, in a way, I think courts have been, the criminal courts have been set up to not succeed by that measure because perhaps they can't.
Well,
Go ahead. Would you like to respond?
No, I agree with Leigh. I mean, the court, international criminal courts have been established also with a view to reaching reconciliation in the countries concerned. However, it's clear that fighting impunity and convicting some perpetrators is a component, may be a component for reconciliation, cannot be the only measure for reconciliation. Also taking into account that in this post-conflict situation, international courts can deal only with a very limited number of cases. In the former Yugoslavia, when the tribunal will close its doors, will have dealt with 1% of the cases, not more. Maybe high-ranked perpetrators, but 1% of the cases, of the possible cases. Rwanda is the same thing. So alternative measures have to be taken into account. That maybe, well, Linda is the expert, what we did in Rwanda with the Kasha system, a truth commission may be established, and now even in the Balkans they are thinking of establishing a truth commission to resolve the problem of reconciliation, because clearly it cannot be done by international courts.
So that's probably a topic that takes us way beyond the immediate focus here, but we could talk about that afterwards. Justice Hedigan, I want to go back to you and let you respond briefly on this issue of accountability to whom, for what, and how, and then open it up.
Well, whatever about the broad general concept of accountability, let's just boil it down to the actual practical concrete reality of the situation, taking the European Court of Human Rights. Who are the judges of the European Court of Rights answerable to? At the present moment they are elected, and up until Protocol 14, which has just come into effect literally a matter of a few weeks ago, they could be re-elected. So you might have said that that was a measure of accountability. Now judges will be, there will be no more re-elections. Judges who are serving certain terms will, by operation of law, have those terms extended to make 9 years. Others will only be elected to 9-year terms, and there'll be no re-election. So that level of accountability is gone, if it ever was such a thing. The only accountability that has ever been really considered to exist is that provided in the convention itself, which is to the court itself. So if a judge is perceived to be some problem as to their behaviour, then it is the court itself which will decide whether or not they should be put off the court, or, as the case may be, reprimanded. That has only occurred in one single instance, and that was in the old Court of Human Rights prior to 1998, and that involved a judge who had received a business class ticket to Strasbourg, cashed it in, and exchanged it for 2 economy class tickets for his wife. That was considered to be a very serious infraction of judicial ethics. He was reprimanded by the court, as a result of which 6 or 8 months later he was not put up by his country for election to the new Court of Human Rights, which was coming up. That's the only instance in which I've come across concrete accountability. The second question that was asked was, for what? Well, clearly you can't have judges accountable for the decisions that they make. That's what they're there for. You may agree or disagree. That's tough. The one thing we all agree is the judge and is going to decide. If there weren't any issues between the parties, there wouldn't be a case. So the judge can't be accountable for the decision that he or she makes. That simply doesn't work. It's not constant with the rule of law. The only thing I think that they can be accountable for is their conduct, bias, fraud, crookedness, or other extraordinary behaviour, as some aspects of which we heard referred to, over-involvement in public affairs and so on. There may be a whole range of things that they may be accountable for. And the how, I think I've already covered, because it's the how is in the Court of Human Rights. As to how it works in the other courts, I quite frankly have to own up, I do not know. But in the Court of Human Rights anyway, it is the court itself that decides.
Thank you. Well, I know I've left very little time for questions, but who has a question? Yes, Ram.
Thank you. My name is Ram. I'm from Nepal. I have a different background here. I'm a GST student at Judicial School. I have experience that is being involved in the election process of some international, including judicial institutions like in ICJ. I was also involved in the election process of ICTY. And perhaps I might have voted for him too at the time. I feel that because we are talking about being involved in the election process of international judicial institutions, the decision-making process, though individual state cast their vote supporting any particular candidate from particular nation or particular region, the issue comes here because my experience for something like 15 years from Geneva to New York, electing committee, say I was involved in the election of these human rights treaty bodies, also including human rights committee against torture, and my own involvement in the presentation of Nepal's report before the Committee Against Torture and Human Rights Committee, and Judge Pocar mentioned about that the member of the any human rights expert member in that committee at the time of the presentation of that country's national report, if happened to be that committee member, usually he keeps silent. He doesn't make any comment in this, and basically at the time of making comments in the recommendation of this committee, he gets out of this, and only the committee, government's expert respond to the questions posed by the committee members. So it is this kind of controlling biasness of the committee expert. And in regard to this election process, I think we talked about the nationality, but in this, we do not much focus on the nationality issue at the time of election.
Right, right.
What we focus on about international political situations and regional context. Basically, all these instruments governing the elections of these international judicial bodies talks about the election procedure.
Right, and I think
you might have noticed about in 2003, I was also in the United Nations headquarters building. We were able to elect the one judge in the International Criminal Court after the 43 rounds of ballot. That was also interesting because there was so much contentious way it was prolonging the election. Balloting.
So, Ram, let me just, so your question is about the election process or the selection process of judges?
Yes, and the selection process itself is not much focused on the nationality issue we just talked about. We had plenty of discussion about the nationality. Yes, because even the ICJ candidate and candidate for the ICJ member can be nominated by more than one nation. So it is a group of nations can nominate one country's international, that means lawyer or whoever is a judge at the highest court of the state. My issue is I have one question, particularly whoever will be able to this. The question comes, when we talk of this international, are we really trying to see that body acting or delivering its function or responsibility in the international, covering the international context, international perspective, rather than, though this is, my view is that means because it's a composite of national, regional composite and international level. And accountability, Professor Honorable Judge Hedigan mentioned it, because I have same thing in my mind, that these international judges are accountable to their institutions, and that institution is accountable to the body which created it. So in the main sense that it's not one single state, they are not accountable to one state.
Ram, I'm really sorry, but because of time, let me kind of capture that and then go maybe have another question, and then we'll let everybody comment on it. So the way I understand your question, it relates to the selection of judges as well as, the spheres of accountability. Okay, another question that somebody has. Yes, please.
This is for this panel. You mentioned about terms, and I can see the value of terms in an international body, but I wondered, and I'd love to open this to the others who've spoken as well, is term limitations a solution to the bias issue, or would term limitations exacerbate the bias issue?
Okay. All right. Who would like to comment first? Briefly.
The selection of judges, I'm not going to get into it because I know myself
it's too big a
Fausto knows,
topic.
it is a colossal topic. The complexity of the selection of judges is just unthinkably complicated, as one would imagine it would be the case where governments are going to bring themselves or within the jurisdiction of an international body. They have to be very careful. So I don't think we can go into that today. I like the question about term limits, and that was a big issue at the time of Newt Gingrich and all that in America here. And I remember
I told you he knows everything about the U.S.
Well, I remember one crusty old politician said in response to all of this, we have term limits, they're called elections. And that was what we certainly had in Strasbourg. I started off as an opponent of the idea of changing the system and having no re-election of judges. And after the first election process, 3 years after I started, I changed my mind completely. And I decided the whole election process was a malign influence on the court and on the whole institution. That it would be much better to have judges elected for one single term. I would have picked a longer term than 9 years. They picked 9 years, 12 years, and leave it at that. That's what I would have said. I think that does have a protective thing from the point of view of bias, because then you know it doesn't matter what happens, you are not going to be re-elected. Now, the one thing that one has to say in relation to that is all provided that the judges are properly provided for in relation to pension rights and so on, which they are not in the Strasbourg court. So we in fact have currently 2 former judges of the Court of Human Rights who are unemployed and stand as a glaring example to other persons who might want to go for the court in Strasbourg, that you are putting your future at serious risk by sitting on that court if you disagree with your government in any way. That's very undesirable.
Well, let me, I can see we could go on for a while, but what I would do is invite you to come up and talk with the panelists after we end and continue the discussions. But thank you very much for your attention, and please join me in thanking our panelists.
So, what does it mean to be an ethical judge? I think in terms of the discussions over the last day and a half, we've had, indeed, as Judge Pocar has indicated, far more questions than answers. But hopefully, out of what you've heard and read, or will go back to read and continue in terms of the discussions, a much more informed dialogue about not only that question itself, but what the questions ought to be. I think, again, starting off with the rather dramatic letter from Justice Stevens, put things into a very different perspective, and we'll be watching American politics and American judicial politics very closely. But from local to global, the issues remain very important about our expectations of impartiality, the appearance of bias, and the dialogue about the rule of law and the role of judges in it. So there's no way I can encapsulate all of it, so let me just focus on offering some thanks again to those involved in this event. First off, to the Sierra Health Foundation, I can't thank them enough, Nancy Lee, their chair, Chet Hewitt, their president, for their continuing gracious and generous support of this initiative and the freedom to take it in directions that are important, I think, in terms of ethics education, both for the McGeorge Law School, but also for the Sacramento and Northern California communities in which Sierra Health is so integrally involved. So thank you to the Sierra Health Foundation. Let me also thank my colleagues, Linda Carter, Mary Beth Moylan, for their work in putting panels together on these important topics. I turn to you for your advice and expertise and for the connections that brought people here for these important discussions. So thank you both in that respect. Thank you to my other colleagues who attended. Julie Davies is just one who's here. This morning we've had a number of the faculty colleagues in and out, and it's a vote of confidence both in terms of your participation to Colleen Truden. Thank you for getting the externs involved and making sure that their education and the work they're doing for judges out in the community is enriched through these discussions. John Sprankling, John Sims, Heather McFarlane have all offered their support. A number of colleagues couldn't be here as well but wanted to be. To all of the speakers and panelists, thank you very much for taking the time, making the effort, traveling, and sharing with us your wisdom, your insights, your ideas, putting it down on paper so that we can all consider it at greater length and respond to you. We didn't throw tomatoes at Mark Harrison, and I don't think anybody's going to get tomatoes thrown, but hopefully at least in putting the ideas out there, you'll find productive feedback that will help enlighten your own thinking, and that participating in this dialogue has advanced your own interests. We're very grateful to you for the time and effort in that respect. To the law review students, Evie Grosnick and Danny Kim from this year's edition, Jessica Lee and Katie Nystrom for next year, thank you very much for your work and your support, and to all of the law review students who are here. To my students from both the legal ethics and legal profession class and the ethics for the government and public lawyer, sometimes mandatory can be okay. So, and in that regard, at least, we've got support as well from Lee Lee, Lindsay Yoshitomi, Jocelyn Blinn, Keir Wilkinson, Adam Guernsey, Ashley Meyer, and Clemence Kuchera, as all of the speakers and panelists know, do just a tremendous, tremendous job in terms of making sure that I keep the trains running on time, and that the speakers and panelists have as pleasant an experience here in Sacramento, getting here and while you're here as possible, and my thanks to them. And to Dean Elizabeth Parker, thank you very much indeed for your continuing and ongoing support. Your presence here over the last day and a half is both noted and extremely important in terms of your vision of both ethics education for the McGeorge community and your commitment to globalization. I think that it's unparalleled, and we're all in your debt in that respect. So, to all of those people behind the scenes, Todd and Ron in AV, everybody else who made it happen, and particularly to you for attending. Thank you very much indeed for your contributions, your continuing support. Hope you found fruitful ideas to carry forward in terms of the dialogue and discussion. Thank you very much indeed for joining us, and last word to you, Dean Parker.
Well, Paul, you've done what I always like to do, and that's to say thank you. You've done it so much better than I ever could. I'll just limit my comments then to say that I'm one that believes that the jewel of our legal system is our courts. Our courts are remarkable in the United States. I also believe that our legal system in the United States is the common language, the common culture that unites us. And it's wonderful to think about how the judicial system could be developed in not only other countries, some countries share our traditions, some perhaps are learning about the role of the judiciary, but to hear the international side and to see what the future might hold there is particularly rich, and so that's very exciting. And I think I would be remiss if I didn't particularly thank this panel. We've had a partnership with Brandeis now, I think that goes back to 2002, and so here we have wonderful opportunity to welcome this special partnership here to McGeorge. And I should say, for those of you who haven't had enough yet, I might put myself in that category. On Monday, we're going to do another session called Blending of Civil and Common Law Traditions. And I might just simply say that this is a special first in another way. We're going to have our Pacific Conservatory of Music here as well. And so we get a chance to do in a real way what Sandra Day O'Connor once described as demonstrate the music of international law. So in several different ways. But thank you to the audience as well. This has been wonderful. And what more important topic than ethics, accountability, and judiciary. Thank you.
Thank you very much. Thank you all very much. Say Paul.